Ready? 3, 2, 1, start. I have heard learned counsel for the parties and considered the case laws relied upon. Stop. The controversy centers on the interpretation of the expression whether the 3 years commencing from when the right to apply accrues under Article 137 of the Limitation Act 1963 implies the date of death of the testator or any other event which constrains a party to approach a court of law for taking the first step for implementing the will of a testator. Stop. It is clear from the above that although Article 137 applies in cases of grant of probate, the right to apply accrues not from the date of death of the testator but from which the dispute arises or when it becomes necessary to apply for grant of probate. Stop. In other words, a party may apply when a challenge is made to a will or a dispute arises in relation thereto. Stop. It is also clear that there is no outer limit for filing an application for probate and the time starts running from the date when the right to apply accrues. Stop. The facts of Arvind were almost identical to the present case where the petitioner in a revisional application had urged that the right of the executor to apply for probate accrues the moment the testator dies and limitation would therefore begin to run from the date of death. Stop. The court considered both Kumarjit Singh and Krishan Kumar Sharma forming the seat anchor of the applicant's case and held that the right to apply has to be interpreted in the perspective of the dispute which has arisen and which makes it necessary for grant of the probate to the will and further that the 3 years under Article 137 would apply from the date on which the right to apply accrues. Stop. The Supreme Court's view in Kumarjit Singh, Krishan Kumar Sharma and that of the Calcutta High Court in Paritosh Patra to the effect that Article 137 of the Limitation Act is applicable to probate proceedings cannot be called to question save that the right to apply has to be construed in the light of the dispute which forces a party to apply for grant of probate. Stop. Neither of those decisions says that the 3 years must be counted from the date of death of the testator or that the right to apply would accrue as soon as the testator dies. Stop. Para. With regard to the second point raised by the applicant oblique defendant number 1 that the provisions of Order 7 Rule 6 stop over